You're being mistreated at work, you're being sexually harassed, or you're being denied opportunities that are being provided to persons of a different race or a different gender or a different religion, or your boss is giving you a hard time after you reported discrimination or harassment. What should you do? Well, today that's what we're going to be talking about, and we're going to start right now. Okay, if you're being mistreated at work, one of the most important things you can do is to keep a journal of it. It can either be handwritten, it can be typed out, it can be emails to yourself, whatever is easiest for you. You need to write down the who, the what, the when, the where, witnesses to it. And the reason you need to do this is because, unfortunately, the wheels of justice move extremely slowly. I know that here in Los Angeles County, an average civil case can take, if you're lucky, only 2 years, sometimes as much as 4 or 5 years, sometimes even longer, unfortunately. And what happens is that with the passage of time, you're going to forget a lot of details. And so keeping these notes are extremely helpful to help you remember these details if you need to testify in your case and at trial. It also helps enhance your credibility too. The very fact that you took the notes in real time enhances your credibility. And in some cases, the notes themselves can be used as evidence at trial. In addition to maintaining a journal of the mistreatment and what's happening to you at work, you should also maintain a journal of your emotional distress. How is this affecting you? Are you losing sleep over it? Are you becoming irritable and you're getting into more arguments with the spouse? Have you developed any sort of high blood pressure issues? Some in extreme cases, the stress from work will cause people to get shingles, which is very painful. Maybe you're having nightmares, you're losing weight, gaining weight. There's a lot of different ways that emotional distress can manifest itself. And so keeping a journal and writing down the dates when you felt certain symptoms, again, just like what I was saying earlier with the mistreatment, it's going to help you remember these things. And if you want to be able to recover on your emotional distress and maximize the award, then you really need to be able to point to specific harms that you suffered. It's not persuasive just to say, yeah, I was bothered by it. What we want to do if we go to trial in these cases is we want to really show the jury how it affected you. And so maintaining a journal is one of your best tools to help you remember all those details at trial. Another powerful tool to use if you're being mistreated at work is to send recap emails. So, let's say that you get presented with a bogus write-up, you get presented with a bogus personal improvement plan. In addition to, writing out what happened to you just for your own journal, after that meeting, you can send a recap email to the participant and say that we met on such and such date, we discussed this and this and this, you gave me XYZ goal, I shared my concern about ABC. If your understanding is different from mine, please let me know. This is powerful because, number one, you're memorializing what happened, you're documenting what happened. But number two, it does help to it helps the others to nail the other side down. And what I mean by that is that if they have a different recollection of what happened, then they're going to respond to that email and they're going to say their recollection. Unfortunately, they sometimes lie about it, but frequently they will admit to certain points, or they don't respond at all, which implies that they don't disagree with your recapping of events. So no matter how they respond, it's going to be helpful to you in some way. This might be the single most important piece of advice. You have to complain to human resources. If you work for a really small employer and they don't have a human resources, then you got to escalate it up the chain of command. Go to your boss's boss, go to the owner. And you need to complain. You need to complain in writing. Okay? It's very important that it be in writing, because unfortunately, if you get into litigation, employers are not always honest and truthful, and they will frequently lie, and they will frequently pretend things that happened did not happen. And so having it in writing, they can't dispute it once it's been put into writing. The reason that it's important to complain is, one, in a lot of cases, the failure to complain by the employee could be a defense. It could actually be an affirmative defense in harassment cases sometimes. And even when it's not a legal defense per se, the employer will use it to say, oh, it must not have been that bad. If it had been that bad, he or she would have complained. Or they'll say, well, it didn't happen at all, right? Because if it would have happened, they would have complained. And so it's really important to nip that defense in the bud. The other thing it does from a practical standpoint is it gives the employer an opportunity to actually fix and address the problem. And, sometimes employers do the right thing. The other thing that it helps you with, and this is more of an optics thing, is that it helps you with the jury. The jury wants to see that you tried to work with the employer, that you didn't run to the courthouse as soon as you had an issue at work. Finally, it's really, really important that when you complain to human resources, stick to the facts. Don't speculate about things you don't know about. Keep it very polite, keep it professional, avoid name calling, avoid casting any sort of aspersions. Remember that this is something that the jury is likely to see if you ever have to file a case. And so you want your complaint to be unimpeachable. So, in fact, I would even suggest, have, a spouse, have a friend, have a lawyer read over the complaint before you submit it. Don't send the complaint when you're angry. Wait a day, sleep on it. Wait until your emotions have calmed down a little bit, and then send that complaint. All right, so we've talked about things you should do if you're being mistreated at work. I'm going to very briefly go over some of the things you should never do. One of those is you should never secretly record a private conversation. In a lot of states, that is a criminal violation, including here in California. So a lot of employees, they think that nobody's going to believe me, and, I have to record this conversation so that I have proof of how I'm being mistreated at work. You can't do it. Don't do it. And, talk to a lawyer, because it's not as difficult to prove these things as you may think. The next thing is that you cannot steal company property. So, you can document things for yourself about what happened, but, you can't take the company's, customer list, any sort of proprietary, confidential data. The employer might, potentially be able to sue you for that. So there are certain things that you are allowed to keep, like if, personnel file, performance evaluations, things like that. If you're raising a complaint to human resources, you definitely should keep a copy of that. But try to avoid retaining anything that has any of the company's confidential proprietary data. And the one last thing that is probably the most important thing not to do, don't email lawyers from the company email. All right, if you need to contact a lawyer, use your personal email, and frankly, try not to even do it on the company computers. The reason I say that is because it's very, very likely that somewhere tucked into your employee handbook, there's probably language in there saying that the company has a right to monitor your personal, or excuse me, the emails you send from the work email, emails you send from the company computer, and there's no expectation of privacy. And, you know, believe it or not, if they've given you that disclaimer that they have the right to monitor the emails and monitor your activity on their computers, then, you know, they can actually read your confidential private emails that you send to attorneys. Those are privileged. They have no right to read them under ordinary circumstances. But if they've given you that disclaimer that you don't have any sort of expectation of privacy, then in most states, I think all states actually, once they've given you that disclaimer, then, you know, it's fair game for them to read the emails. And, you know, obviously you want whatever you tell an attorney to stay confidential between you and that attorney. Thank you for watching this video. If you found it helpful, please like it below. Please click on the subscribe button to catch all my videos as they come out. If you have any legal issues at work and you are based in California or live in California, you are welcome to call me at 888-376-7849, 888-376-7849. Thank you again for watching.